Yes, Mr. Wilson.
Yes, my Lord. I've just via your clerks, I've handed up a copy of Goodwin. You've heard much about it, but you don't have the thing itself.
No, that's helpful, thank you. And we've also, we were kindly supplied with the grounds as presented.
Yes.
To the EAT.
Yes, thank you. The reason I've handed up Goodwin in particular is following questions from my Lord Justice Jackson on where should the focus lie? Should the focus lie on what the individual is in fact doing? And of course, the focus following Goodwin is on what the individual cannot do or faces difficulties doing. In the interest of time, can I just flag 308H to 309E? The court may be interested as well in what the then President said as to the approach to the predecessor guidance at 307F to 308B. I don't, as I say, in the interest of time and my allotted slot, I'll ask if you can read that in due course.
So the first one was 308H to
309E.
Right, so that's
and guidance.
Substantial passage, yes. Would you like to just pick the bones out of it for us and we come back and read it?
Yes.
Not in your time, as it were.
Yes. In a nutshell, the focus of the tribunal's inquiry must be upon what the individual, in fact, is not able to do, and whether the ability to do that which they do is substantially affected, particularly where disability is, as in Goodwin, which was a case involving delusions brought on by schizophrenia, but certainly paranoid delusions and persecution complexes. An individual may be keen to play down the effect of the disability on daily lives or suppress it for other reasons. That's 308H to 309E. And then on the guidance, the code of practice, the predecessor to the paragraph of taking to shall be taken into account. At the top of 308A, in this case, the Industrial Tribunal made no reference to the guidance. It should have done so, we think. We're on duration. And I just wanted to make it clear that there are two ways in which duration can be established, by reference to the past or speculation as to the future, either duration of 12 months or more, or recurrence, even if the recurring episode does not last longer than 12 months. And so that's where we were picking up just before lunch, the error that the tribunal seemed to search for a recurring episode that lasted 12 months or more, notwithstanding the fact that this was the second recurrence. I think you also have the point that there's something of an oddity if the effect of the predecessor provisions under the DDA is not transposed. Why should a tribunal treat 2017 as ground zero in circumstances where it is known that there is an underlying condition and that this is a recurring episode? Why does it look to the future when it is well established that the condition and its effects, albeit recurrently, have been going on for 4 years in the past? So with that, we come to likelihood of recurrence or duration speculatively, the real possibility issue. And we were on paragraph 101, page 131. And it's my submission, firstly, that likely should be, when used in the same two sentences, should be interpreted as meaning the same thing. And this is what the tribunal says. That the pay discussions, were not going to continue indefinitely, and it was likely that his condition would improve once they were resolved. The tribunal concluded that so far as this episode in 2017 is concerned, it was likely that the substantial reverse effect would continue like that of 2013 for a number of months, but for rather less than 12 months. And so we see again that they're searching for a 12-month recurring episode when no such inquiry is required. Likely there, on any reading, means more likely than not. What the tribunal is doing is providing its own prognosis as to what was more likely than not happen. And having done so, it says, well, since it's likely that the condition would improve at the end of the pay discussions, it's likely that the effect would be less than 12 months. What it does not do is ask itself whether there is a real possibility that those number of months may persist, or that there may be another episode. And this is in a scenario where, in a different context, the tribunal did postulate the future when it came to the Polke assessment. At 119, page 134, the future model, which leads to 6 months of employment, is one involving warnings and the pursuit of a process that leads to dismissal. Where in the tribunal's reasons does it consider that that model of a future course had a real possibility of leading to recurrence or a prolonged duration? And the reason it's not there, we submit, is that notwithstanding the one-sentence direction to Boyle in paragraph 92, it did not ask itself the correct legal question. The question is not what is the effect of this trigger event, the pay discussions, but is there a real possibility of a trigger event? And the tribunal identified one such event: the pursuit of a process involving warnings and culminating in dismissal. And nowhere in the tribunal's analysis does the true legal question find itself answered. And the point is made, for understandable reasons, by my learned friend and by the EAT, that I'll be ready to say that, having directed itself to Boyle, the tribunal, notwithstanding the obvious words and plain words of para 101, fell into error. Well, it would not be the first. I'll just take you, I'll provide the paragraph numbers if I may. Patterson at tab 6, para 7. Fathers and Pets at Home, paragraph 37 at tab 10. Dorset, tab 22, paragraph 72. And the citation of Thompson, paragraph 18 of the respondent's submissions. In each of those occasions, in this field, the EAT accepts that there's an impeccable self-direction, but nonetheless a misapplication when it came to the facts. And that's not a perversity challenge, that's a challenge of legal error and legal approach. So even if you're against me on ground 1, there is no substantial adverse effect. Look to the position at the date of dismissal, and nowhere in the tribunal's judgment is there anything which grapples with the fundamental question where there is a single underlying condition and where there is a medical prognosis that in the joint report, more prolonged interventions are required for a good prognosis. And in the report of Dr. Watson, conspicuous by its absence, the underlying impairment would have made him much more susceptible to a reactivation of his overt symptoms dependent on the level of stressors. The real analysis, akin to that in Adorami, is that unless it can be concluded with confidence that there is no real possibility of recurrence or duration in excess of 12 months, an individual is to be treated as disabled. The passport should be conferred, and the destination should proceed substantively to the questions of liability. Ground 3 and final ground, knowledge. If you're with me on either ground 1 or 2, the indirect discrimination claim and disability have to be remitted. The knowledge finding is not determinative of that claim. The knowledge requirement of reasonable adjustments and Section 15 is a requirement of actual or constructive knowledge of the disability, and in the case of reasonable adjustments, the disadvantage as well.
Before we leave Miss Watson, I think this point has been made before, but paragraph 38
Yes.
Is where they summarise the notes.
Yes.
I mean, your complaint appears to be that they don't talk about her report.
Yes.
But why would that be likely to be a foreground issue for the tribunal? Isn't Miss Watson really there in order to bear no doubt reliable witness to what the situation was on the ground, rather than to start opining about it?
Her report goes considerable stages further than simply the contemporaneous shorthand notes. She postulates that at the point of, or assesses that in 2014, the interregnum period, there is likely grounds for a psychotic disorder. And she provides considerable detail on the effects as at 2014. She provides material on the fluctuations of those effects. And of course, there were fluctuations in 2014 which prompted the claimant to see a psychologist or a psychiatrist in the first place. And she also, on the basis of what she has been told in 2014, gives an important assessment as to the prognosis of his condition. Now, in circumstances where the question is, for ground 2 purposes, is there a real possibility of recurrence, fluctuation, extended duration? That is important material.
I don't want to labour this point, but just because you've mentioned it several times.
Yes.
Miss Watson saw your client for 7 sessions between May and September 2014.
Yes.
Dr. Wise interviewed him for the purpose of the joint expert
Yes.
report. What dealings did Miss Watson have with your client subsequent to September 2014?
She was asked, and you see the instructions, to provide a report based on her observations in 2018, but there were no further clinical sessions between 14 and
Yes. So
18.
she hadn't seen him for something in the order of 4 years.
Yes.
So what would be the point in her providing a report on the matters that? Why would her reportage looking back to 2014 take matters beyond what she said in 2014?
Because she's giving a fuller clinical assessment as to what she observed in 2014, beyond a page of shorthand notes. So it provides important context on what those notes mean and what prognosis the condition as revealed in 2014 might have.
But why wasn't that material covered in the joint experts?
It was.
Sorry?
The report of Dr. Watson is cited by Dr. Wise.
No, but if this is an important issue, my question is, why wasn't it covered in the instructions to the joint expert, or was it?
As I say, the report was before Dr. Wise. The letter of Louise Watson is cited at paragraph 15, page 43 of the supplemental bundle.
That's not the question I was asking, but I'm probably not asking it clearly enough. My question is, the issues that you say are covered more fully in Dr. Watson's 2018 thoughts. Why weren't those issues covered in the report of the jointly instructed expert, i.e. Dr. Wise?
Forgive me, my lady, what specific issues are absent from Dr. Wise but present from Dr. Watson?
Well, exactly. So why does the tribunal need to look at Dr. Watson's thoughts if they've got a jointly instructed expert reporting on those matters?
Because the tribunal is departing from the conclusions of a jointly instructed expert, because that expert isn't sure or can only rely on what's said. A complaint that could be made in relation to any in relation to any mental health condition or mental health assessment. What Dr. Watson provides is an assessment in real time in 2014.
Nobody's complaining about that.
Yes.
But her notes from 2014 are clearly a matter of some importance.
And the context of those notes and what those notes reveal, set out in further detail in the letter, is also of importance.
But just so we have the litigation chronology.
Yes.
Your client solicitor wrote on the 10th of February 2018 to Miss Watson,
Yeah.
which will have been the first time that she came across him since 2014, saying, we've got to issue a claim by next Saturday.
Well, I'm not sure about that.
7 days hence. That's written on a Saturday, and on the Thursday she provides her report, and no doubt her notes with it. And then after that, no doubt that's considered to, I'm speculating here, but to be sufficient to allow for the court to approve a jointly instructed expert.
Yes, I'm not sure of the chronology. The one thing.
Well, I'm looking at your bundle, which is what the sequence of events is, and so she provides a report, which then leads to this topic getting the consideration it deserves. But my lady's point is, I mean, hasn't in a sense, isn't it entirely a matter for the tribunal what sort of weight it gives to a later non-court sanctioned letter from Miss Watson, provided before the proceedings are started? It's up to them, isn't it?
Well, nothing's been said on it at all.
Yes, but I'm putting to you that that's presumably because they didn't think that it helped them.
We just don't know, my lord. It certainly helped the joint expert because he refers to it.
Exactly. Well, you've got the joint expert, and your point about whether sufficient regard was paid to his opinion is well understood. Right. I'm sorry to have.
No, that's fine.
And don't. My intervention doesn't eat into your time, so you're going to deal with ground 3.
I'm very grateful, my lord. Thank you.
Thank you.
We were on knowledge, and the important point to make is that it is a defence to a discrimination claim under Section 15 and Section 20, and it's a defence which the employer must prove. And it's an onus which an employer may fail to discharge. It is possible, for example, for a tribunal to conclude that an employer has had enough to be put on notice that ought reasonably to make inquiries. There's a failure to make those inquiries, and there's no real certainty as to where those inquiries might lead. But in that scenario, the reasonable steps or the reasonable constructive knowledge defence could not be made out. In those circumstances, the employer would fail to make out the defence. It's only where a tribunal can confidently conclude that the steps would have no prospect or no real prospect of leading to knowledge as to the ingredients of disability that the defence is satisfied. The EAT, there is nothing, incidentally, in the tribunal's judgment on knowledge as a matter of legal analysis. It says nothing about it at all. The principles on knowledge are set out in A and Z, tab 17, and in particular paragraphs 41 to 42. Forgive me, 23. Apologies, 23 first. This is tab 17. Need only be actual or constructive knowledge as to the disability itself. Need not be aware of the diagnosis.
I'm sorry, which paragraphs?
Paragraph 23, my lord.
You say there's nothing about knowledge. Do you mean that there's nothing substantial? Because paragraph 105 said the findings above would lead the tribunal to conclude the respondent did not have knowledge, including what it would reasonably be expected to know of that disability.
there is nothing when it comes to the legal test for knowledge. The sum total of the direction as to law is the 4 paragraphs at 88 to 92. None of them address the correct approach to knowledge. So clearly there's a conclusion as to knowledge. It's the basis of the appeal on ground.
What's wrong with the with what appears in paragraph 105 as as setting a question and answer?
Well, because the tribunal has to consider not only what the individual, what the corporate employer knew, to which the observations of Mr. Iseo have no material bearing where others were aware of the condition, but what they ought to have known had they taken reasonable inquiries. And we know, for example, that the tribunal is critical as to its approach to the medical inquiries because it's a basis, or one basis, of the unfairness in the dismissal. Paragraph 84.
But I was only picking you up on you saying there's nothing about knowledge.
Forgive me, there's nothing in terms of legal direction as to knowledge. I stand by that, my lord.
And did there need to be a legal direction, and if so, what did it need to say?
That the question of constructive knowledge requires the tribunal to consider what the employer knew and what it ought reasonably to have known had it taken reasonable inquiries.
How does that differ from paragraph 105?
Oh, my lord, that's not a legal direction. That's a conclusion. That's a bare conclusion by reference to not what steps ought to have been taken, but what was actually known. The question of constructive knowledge is not really addressed at all.
Hang on, the words in brackets.
Well, but the question is, what inquiries should this employer have made? What were the real prospects of establishing knowledge had those inquiries been made? That's just not addressed. But the problem is more fundamental than that in key respects, because there was a great deal that this employer knew. In fact, the EAT accepted that on any proper analysis of the position as at 2013, this employer knew that the effects were substantial. And there's no other way of reading the judgment. Paragraph 26, 114, completely fixated, overshadowing everything in his life, in a bad place psychologically, shaking and sweating. I sense paranoia. We then have the tribunal's observations at paragraph 29, page 115, that there was a conscious decision not to refer to paranoia on the file, presumably because that would open inquiries. And then we look at paragraph 30. Mr. Hodgkins said in evidence he thought the claimant needed professional help, was not attempting to diagnose. Mr. Drake said the claimant was clearly suffering from some sort of paranoia or mental illness. And then we come, as time continues...
Well, the tribunal agreed.
But it also held that the respondent lacked knowledge. How can that be so? On its own findings.
Knowledge of what?
Yes.
Knowledge of substantial adverse effect, at the very least of 2013. Time goes on, and we see, for example, at paragraph 39, position in July 2014. A year after the paragraphs I've taken you to, Mr. Drake, I'm sorry you're still suffering from some issues with the spooks. Please, do you have some sort of professional support on this? Then we have December 2014, paragraph 46. Mr. Drake and Mr. Hodgkin refer to paranoia. Again, paragraph 49, page 120. 10th of April 2015. Either he has a mental problem we need to discuss with him and help him with, or he is being obstinate. No such discussion was had.
So you say that at least at the time when there were sufficiently florid symptoms for it to have been subject to this email correspondence, for example, at the various points between Mr. Drake and his colleague.
Yes.
That the tribunal was bound to find that at that point they had knowledge.
Yes.
And so where at 105 they say not disabled during his employment or any part of it, but if we're wrong about that, we conclude they didn't know about the disability. You say, well, they'd have to at least say they didn't know about it at other times, rather than across the whole of the employment.
Yes.
To be internally consistent.
Yes.
I understand.
And the analysis of the EAT is the missing ingredient for knowledge purposes is duration. The passages that I'm taking you to refer to continued knowledge and continued discussion. End of 2013, 2014, 2015. 2017, paragraph 71, page 125. The issue we both know is that we are dealing with a paranoid person. Previous paragraph 68 and 70 look very bloated, sleeping badly. Paragraph 70 look terrible. And then 79, Mr. Drake responded at the bottom of 126. This is before a medical note arrives, but it's a note that's anticipated. Mr. Drake's response to Mr. Hodgkin was to say in an email, I don't see why he can't come in to discuss as requested. He isn't contagious or bedbound. We say that the reasoning of Para 105 is impermissibly short, has no relationship to the findings that the tribunal reached. And in any event, if there was an absence of knowledge, it failed to ask itself the fundamental legal question, what steps should this employer reasonably have taken and what may they have yielded? And all of that is missing. And for that reason and the reasons set out in my submissions, the knowledge ground must succeed. The EAT's attempts to fill the void on this point, particularly at paragraph 51 and 52, fall into the very trap which this court deprecated in Anya, which is to fill the gaps of a judgment which, whatever its worthiness, is lacking in material respect. And so what point of the jigsaw on knowledge is missing as at the point of dismissal? Those conclusions in mind, I ask you to uphold the appeal on all three grounds, although as I hope I've made clear, if you're not with me on ground one but still with me on ground two, the claimant should be treated as disabled, at the very least at the point of dismissal. And so the question becomes one of disposal. It is notable that notwithstanding the fact that that there has been, that in those cases there was neither a perversity argument raised or one which was upheld, the court, the EAT, has nonetheless held on no less than 3 occasions, 4 in fact, Goodwin, Abiday and Patterson, and J, and forgive me, 3, not J, Abiday, Goodwin and Patterson, that on proper self-direction there can only be one conclusion, which is that an individual is disabled. We say that that's the case throughout the material period, including 2013, if not, at the very least, from the position of April 2017. That, at the very least, for the purposes of 2017, the conclusions on knowledge must be established, at least as to knowledge of the disability. To the extent that there are any remaining questions, they are to be remitted to the same tribunal as the ordinary course, but we are open to a differently constituted tribunal. For the reasons that I set out at the outset, the questions to the likely trajectory of the claimant's employment, the Polke question, must be also set aside. The reason I'm opening this, forgive me, you asked me about CAP. The joys of live streaming is that I can get things virtually thrown at me, as well as behind me. The statutory cap for unfair dismissal, as at April this year, £89,493, or 1 year's salary, whichever is the lesser. And you've seen the figures which the claimant was earning.
Is that salary or salary and bonus?
Both, the whole caboodle. So compensatory loss cannot exceed 89,000 or a year's salary, whichever is the lesser. The current top of high band vento for injury to feelings, the injury to feelings is the measurement, the vento is the measurement of injury to feelings, £45,600. This is a consequential appeal, my lady, my lords. It's one in which the tribunal portrayed a number of errors as to the correct legal approach, and we therefore ask you to uphold it. Unless I can assist further.
I just ask you, you would say, I think, that the document that was filed before the EAT in getting permission to appeal maps the grounds of appeal which you've in fact presented.
I believe it does. That there's a difference as to audience.
Well, I wouldn't argue about it.
But certainly there was no intention to sneak in anything that wasn't there before the EAT. Of course, the arguments of the skeleton are fuller, but the grounds are
As a
materially identical.
quick glance, I can't find any reference in the EAT grounds of appeal to the para 5 of Schedule 2 to the DDA argument.
No, that's a statutory construction point as to how duration and likelihood should be interpreted.
I understand what the point is. I'm just saying.
Rather than a freestanding ground.
All right.
It was certainly ventilated before the EAT, and the EAT reached conclusions on it.
All right.
As I say, it's a matter of statutory construction, fundamentally. But I say that is properly before you and has indeed been properly responded to by Mr. Lee.
Thank you very much.
Thank you very much.
Yes, now, Mr. Lee, we've had a thorough tour of the issues so far, and I think what I'd like to ask you to do is to give us the highlights package of your submissions first, and then we'll consider where we might go with that. We've carefully read your very full written skeleton argument, and so we don't want to get involved in simply following that through all over again. So could you try, please, to give us the main points as you would respond?
I'm grateful. If I could just, my love, for 1 moment ask if Mr. Nelson can pass me the lectern.
Of course.
Sorry.
Absolutely.
There you go. My lord, yes. I'll try and do the highlights package, as it were, of my submissions. The court will no doubt have from my skeleton argument that this is essentially a challenge that is based on, at least insofar as its grounds 1 and 2, insufficient or inadequate reasons, or perhaps that the court should infer that the tribunal, it is not a case which in my submission raises large issues of legal principle about, for example, the definition of disability. What I had intended to do in my submissions, just to roadmap where I was going to go, my lord, was to briefly take the court through paragraph 98 in particular, but that section, because in my submission the point made by my lord Lord Justice Singh in argument when my learning from it makes submissions about that being the crux of this appeal, really is the crux of this appeal, what it turns on. Just slightly before 98, because that takes in the tribunal's self-direction, but essentially those paragraphs are what matter in this case. So I'd intended to go through those and make what points I had on those at the outset, just to try and avoid having to dip through and do that too many times. In respect of ground one, I then intended to tackle head-on the suggestion, although having heard argument, I don't know to what extent this is pursued in full, but the suggestion that I had understood was made in my learned friend's skeleton argument is that in effect, whenever there is a delusion present, the effect of the statutory guidance is that there must also be taken by the tribunal to be a substantial adverse effect which derives from it. That wasn't pressed overly hard, I don't think, in the end by Mr. Milson, but I was going to tackle that head on, as it appears to me, insofar as there's a point of law here, that is it. Otherwise, and after that, I was intending to go through the things which were said by Mr. Milson to be defective in relation to the reasoning, which I think fall centrally into two categories. Firstly, the treatment of the medical experts, or not experts, as I would say in relation to Ms. Watson. And secondly, Mr. Milson's more general point, which as I understood it, was that the tribunal erred by focusing impermissibly on the perception of others or on the claimant, now appellant's, predispositions, what other people observed in the workplace, rather than perhaps going through those paragraphs that the court was taking to in the impact statement and going through impairment by impairment. Do we accept this one? Do we accept this one? Was it substantial? That was what I intended to deal with in respect of the first round of appeal. I was then going to deal briefly with a point which I say actually doesn't fall within any of the grounds of appeal at all, and that was Mr. Milson's submission in respect of the CJU case in Dawoodi. The reason I say that's not part of the grounds of appeal is that goes only, as argued, to one part of the statutory test, whether or not there was a substantial adverse effect which was likely to last for 12 months as at the relevant time. And in my submission, there is no extant appeal against that aspect of the employment tribunal's finding. That would then take on to ground two, whether, and as I understand it, this is really only pursued in relation to April 17 onwards, whether or not there was a substantial adverse effect that was likely to recur as at April to September 2017. Again, dealing first with the point made by Mr. Milson, essentially by reference to the repeal provisions in the Disability Discrimination Act, that once there has been a recurrence, it must be assumed that a further recurrence is likely. And then, having dealt with that as the point of law, again dealing more briefly perhaps with the points made by Mr. Milson in relation to the tribunal's reasoning on that question and whether or not it's possible to infer that the tribunal applied the wrong test, having stated it. And then finally, on knowledge, I would propose to deal with knowledge relatively briefly, because I have to accept that the tribunal's conclusion on knowledge is stated briefly in my submission. That conclusion was held in the AT was entirely adequate when the decision is read as a whole, but there's only so much I can say to the court on that without going over old ground, as it were.
Right. So how long do you think you're likely to need to deal with those matters at highlight point?
I'd originally said yesterday to Mr. Milson that I'd needed 2 hours, obviously given where we'd got to.
Yes, well, you understand why I've raised this.
Yes, my lord, and so I'd attempted over the luncheon adjournment to take out some of the bits that hopefully in the light form.
But when I say the highlights, I do mean the highlights. I don't suggest that you make the underlying arguments to their very dregs, as it were.
Yeah,
so how long do you?
I would hope to be able to do the highlights within an hour, maybe an hour and a quarter.
Yes. Well, I think that's rather longer than we need for your main points, but you'll have to take your own course. I'm not sure I've got across to you quite.
No, and it might well.
We want to be able to grasp, in the light of the very detailed submissions that we received, what your essential responses are, not to have them argued out to the limit. So what
in which case I will endeavour to be even more. One of the difficulties, perhaps, my lord, and perhaps it's overkill on my part, but it arises slightly from the point made by my Lord Justice Singh at the outset about the grounds of appeal, and with respect there not always easy to pin down exactly what the arguments taken against me are. Hopefully, highlights at that level, my lord, perhaps something more in the region of 20 minutes, half an hour.
Right. Thank you. Shall we start on that basis? And obviously, we'll ask you more about matters that we feel we need to explore more deeply.
I'm very grateful for that, my lord. And perhaps if I start here, and very briefly, because it's a point which the court's familiar with, that this was, of course, an appeal that was heard by an experienced employment tribunal over 9 days with evidence, detailed argument from counsel on both sides, and it was a tribunal which engaged diligently with its task. It's not, for instance, a decision which is all one way. Even on the issue of disability itself, there were findings that went both ways. It's a case in which the tribunal gave itself accurate directions as to the law. And does that mean it's inevitable that the tribunal did not err? No, of course, and Mr. Milson's taken the court to some examples, but it is an inference which this court will be very slow to reach. My lord, what I won't do at this juncture is ask the court to turn up this authority, but a very helpful recent summary of these principles was given by Lord Justice Popwell, and I raise it now because it hadn't been handed down when I produced my skeleton argument, so it's not referred to in there, but that's at tab 20 or at page 371 of the PDF, and in particular paragraphs 57 and 58, Lord Justice Popwell articulates a very helpful summary which should hopefully, and is currently at EAT level, obviating the need to refer to litanies of authorities on these types of issue.
So what's the name of the case?
It's DPP Law and Greenberg, my lord.
Thank you very much. I have read it.
And it makes lots of the points that have been discussed both today and in previous cases, but it does so in one very neat and succinct and helpful summary, if I may say so, with respect to Lord Justice Popwell. So that then takes me to where I was going to go in relation to the tribunal's findings on this. And I think the quickest way to do this in headline, my lord, is by reference to my skeleton arguments, paragraph 16 in page 49 of the core bundle.
Paragraph 16, thank you.
And the cross-references there, and it just avoids needing to turn this up, but the tribunal sets out the statutory provisions. One important point, it was said at one point by my learned friend that there was no direction in relation to the meaning of substantial, whereas, as I've said in 16.1, and this is in the tribunal's judgment, there is a specific reference to section 512 of the Equality Act, which has the statutory meaning of substantial. And also, Boylan, importantly, as I've said there, that's a non-controversial self-direction. There's a summary then of the expert evidence, and that's from Dr. Wise, the single joint expert, and that's not seen as controversial. There's reference to the claimant's witness statement and his impact statement, and also to the sessions of the psychiatrist, Ms. Watson. As the court's noted, there's also reference in the judgment to the handwritten notes, a point which I'll return to briefly. The tribunal directs itself correctly that it's for it to reach its own conclusion on the issue of disability. And the next point is important. This is 16.4 of my skeleton, or 97 of the judgment. The tribunal found that from May 13, the claimant suffered from an impairment, delusional beliefs that had a substantial adverse effect on his ability to carry out normal day-to-day activities of sleeping and social interaction. And I say that's important because one of the points raised by Mr. Milson was, in effect, that the tribunal had failed to engage with what the activities, day-to-day activities were that were hindered. If that's right, it applies just as much to the tribunal's findings in favour of the claimant as it does to the tribunal's findings in favour of the respondent. There's no more detail about the effect of the impairment on day-to-day activities given when the tribunal finds it was there as when it wasn't. The tribunal then looked in detail at paragraph 98 already today, where the tribunal explains why it found that the substantial adverse effect did not persist beyond September 2013. I don't intend to rehearse the reasons there, so I can come back to the adequacy of those, but they're clearly there. What that means is, for purposes of the long-term test, the tribunal has concluded that it's not lasted for 12 months as at September 2013, and nor at any other time, because of course the tribunal finds that that effect returned in April or September 17, but clearly that substantial adverse effect had also not lasted for the requisite 12 months at the time that was required. What the tribunal does find at 16.6 is that there's a deterioration in the claimant's condition, with the result that there was again substantial adverse effects on timekeeping and performance, which arose when he was under stress of remuneration decisions. And this is what the court, the tribunal, has to consider at first instance in relation to the likelihood either of it lasting 12 months or of the likelihood of it recurring, essentially finding that the resolution of those discussions would mean that the effect ceased and therefore would not be likely to last that long, nor would it be likely to recur. As I say, in my submission, there's no appeal from the finding in relation to the likelihood of it lasting 12 months. I will, if I may, just because it led to some discussion between my learned friend and the court, deal briefly with the final sentence of paragraph 103 of the judgment at page 131 of the core bundle. In neither case was it likely that the substantial adverse effect would continue for 12 months or more. In my submission, that's really a point that goes nowhere. It's neglecting to notice that there's two different questions the tribunal has to deal with. One, as at the relevant time, was the substantial adverse effect likely to continue for 12 months or more? If not, was it likely to recur? It's not there saying the recurrence test would only be satisfied if there were recurrence lasting 12 months. It's dealt with recurrence in paragraph 102 above. 103 is merely a reiteration of the conclusion in my submission in 101 that it was likely that it was not likely that it would last for 12 months or more. Those being the conclusions of the tribunal, where it said that went wrong, and as I said, to sketch through my submissions briefly in relation to this point, my Lord, in relation to the guidance, the guidance can't possibly mean that whenever there's delusions present, there has to be a substantial adverse effect on day-to-day activities. The guidance can't, it can't purport to replace the statutory test, but nor in fact does it do so. The guidance itself is a list described as illustrative examples. It is reiterated in the guidance, and for the court's notes, this is page 53 of the guidance, or 598 of the PDF, that the tribunal has to apply the factual test. And I would just add, why only delusions? It's a very, very long list indeed. It can't possibly be the case that each of those effects is automatically deemed by the guidance to have the requisite effect. Moreover, were that to be what Parliament wanted, it has multiple powers within the Equality Act itself to make or deem certain impairments or certain effects to meet the statutory test. It's done so with HIV, multiple sclerosis, cancer, blindness, substantial disfigurement. If Parliament wants to do that, it can. Once it's recognised that what the tribunal has to do is consider whether the impairment, here the delusions, has a substantial adverse effect on the claimant's ability to carry out normal day-to-day activities, and it's accepted that there's no perversity challenge, then the only routes left open are either that the reasons in paragraph 98 for why that ceased when the tribunal found it did are inadequate, or that paragraph 98 has within it some other area of law. Insofar as it's said first that the expert evidence received inadequate reasoning in my submission, that's clearly not the case. Paragraph 98 is the reasons for why the tribunal took the view that it did, and it's not taken against me, and it's accepted that the state of the authorities is that that question of substantial adverse effect is a question for the tribunal. There's no doubting that the tribunal was cognizant of Dr. Wise's opinion that it engaged with it. it didn't neglect it, but it came to its own view as it was required to do. Insofar as what's said instead is, well, precedence had to be given somehow to what Ms. Watson said. The tribunal's seen the notes. The tribunal refers to the notes. This court has seen the notes. Insofar as there was anything relevant from Ms. Watson, it was the notes. The courts looked at the letter of instruction. I think it's going beyond the highlight to deal with that letter of instruction in detail, but it was at short notice. It was not balanced. It was in no way a letter of instruction from both parties. But more importantly, in the disclosure process before the tribunal, it was confirmed that those handwritten notes were all that existed from the initial session. So the only sources of information that Ms. Watson had was what the claimant said to her over the phone in 2018 and those notes. And in those circumstances, the tribunal can't sensibly be criticised for focusing on the contemporaneous notes. Again, as Mr. Justice Choudhury found in the EAT. That then leads to Mr. Milsom's second general category of points in relation to this, which is that the tribunal impermissibly focused on the claimant's own failure to link his issues at work with his illness or his pre-2013 disposition, or indeed the observation of others. The short answer is none of those are irrelevant. They're all entirely relevant. If it's said that undue weight was given to any of them, that is just a different way of saying perversity, which isn't pursued before the court. And in any event, any suggestion that undue weight in the perverse sense was given to any of them is hopeless in circumstances when any one of them was given precedence over any other. Was it then necessary for the tribunal to do what I understand Mr. Milson said it's done, rather than referring to sleeping and social interaction in the way that it did, to instead go through a line-by-line impact statement in the way that it said? In my submission, that's precisely the type of exercise which Lord Justice Popple was saying in DPP Law and Greenberg is not required, and indeed that's the conclusion that was reached by Mr. Justice Choudhury in this case. And I'll perhaps conclude on ground one in terms of the highlights. It's perhaps worth noting that the inclination of Mr. Justice Choudhury himself, when giving permission, was that on ground one alone, he probably would have come to the view that it did not merit permission on its own, and that is in my submission telling of the merits of that ground. Moving to...
It would have been more telling if he'd refused it.
My Lord, yes. One of the issues of the EAT procedure is the absence of the opportunity in this court to make short submissions responding to an application for permission, which perhaps regrettable. The tribunal's finding that the substantial adverse effect was not likely to last for at least 12 months, as at 2017. First, as I've already said, that is not open to Mr. Milson because that argument forms no part of the grounds of appeal, so that is the short answer. Insofar as it's needed, the second headline point, and this refers to Dawoodi, which is at tab 24. I don't need the court to turn it up to make the headline point.
I'm sorry, Mr. Lundy, it's my fault. What exactly is it that you say cannot permissibly be put before this court? I mean, surely Mr. Justice Choudhury has granted permission.
Not in my... So, forgive me, I've perhaps taken the point rather too quickly. If one looked, my Lord, at the grounds of appeal, these are in the core bundle at page 11.
Yes.
Ground one is that the Employment Tribunal and the Employment Appeal Tribunal erred in concluding that there was no substantial adverse effect throughout. That's the point that I've addressed the court on thus far.
Yes.
Ground two, the ET and the EAT, is over the page on page 12, erred in concluding that the appellant did not have a recurring condition.
Yes.
That, in my submission, goes to the issue of whether or not the substantial adverse effect was likely to recur, not whether it was likely to last 12 months. They're two different parts in my submission of the statutory test, two different factual conclusions the tribunal is required to reach.
So what do you accept Mr. Justice Choudhury did grant permission to argue under ground 2?
Under ground 2, the permission was granted to argue that the tribunal erred in its conclusion that as at September 2017, the date. I've said September 17 because it's the date of dismissal, but at the relevant time, the tribunal concluded that the substantial adverse effect was not likely to recur. Mr. Justice Choudhury granted permission to appeal against that finding. The tribunal separately found, as it was required to, that the substantial adverse effect was not likely to last for at least 12 months. They're two separate points, and there's not an appeal against the second of those in my submission.
I'm being very slow, it's my fault. In the draft document, sorry, the document that was an application for permission put in front of Mr. Justice Choudhury, which we now have.
My Lord, yes.
I hope you have as well.
I don't have that in front of me.
Well, that may be the source of the problem. All I was going to put to you, Mr. Lee, is that at page 5, ground 2 in bold type is the same as ground 2 that's now before this court, save for the taking out of the word arguably.
My Lord, yes, sorry, I'm not taking a pernickety point about the distinction between what was before. It's nothing to do with what was before Mr. Justice Choudhury or what's in these grounds of appeal. It's that neither of them, in my submission, encompass the point that Mr. Milson has sought to argue in relation to likely to last 12 months.
Oh, I see.
It's not to, sorry, I should be clear, I'm not taking a point about the distinction between those grounds
Right.
and the Mr. Justice Choudhury grounds. It's just that that point
Right.
isn't within either, and nor, I would say, for completeness, was it in the grounds of appeal for the EAT themselves. They're two separate statutory limbs of the statutory test.
Right. So you say the Dawidi point is not pleaded even in the final version of the grounds of appeal?
My Lord, yes.
But surfaces, you say, for the first time in the skeleton argument?
It was also raised, in fairness to Mr. Milsom, in his skeleton argument before the EAT, and so I should be clear on that.
Can I just draw attention to 105 in the core bundle, which is Mr. Milsom's notice to the grant to the EAT, not from it.
My Lord, yes.
Paragraph 6, where disability and duration appear to be rolled together, and so at least at that stage, the packaging appeared to be put it in under ground 1 rather than under ground 2, which was recurrence. I hope I'm understanding the way it was then put. And so, however it left the EAT, it entered the EAT with duration being a point which was argued and considered. And so, I suppose we have to consider whether, being fair overall, we should take the view that it isn't open to Mr. Milson to address us on that point in circumstances where he argued it all the way in the EAT.
And my Lord, I suppose it depends what one takes, whether duration is sufficient to put the entirety in issue or not. I don't intend to press the point further. I think.
All right. Well,
the court has my point.
You're not dealing with this at length anyhow. But by all means, say anything you'd like to say about duration, so that for safety's sake, or necessarily, we have what you want to say about that.
I mean, and I can deal with this briefly, because the point in relation to Dawidi is essentially, as I understand it, that what approach the tribunal should take is to say, if there's an open-ended prognosis, then in effect that's enough. And in my submission, that's not compatible with the equality. More important.
You mean an uncertain prognosis?
An uncertain, yes. That's not what is said in that case. If one looks at paragraphs 55 to 58, and for the court's notes, that's tab 24 in the PDF, it's page 455. All that the CJU is saying there is this is a factual test, and it might be possible for it to be satisfied by there being an open prognosis. However, the referring court must consider this. It is entirely not the same as saying whenever there is an open-ended prognosis or an uncertain prognosis, the only conclusion open to the referring court would be this.
I noted when Mr. Milson was making his submissions this morning that he used the word may.
Well,
Is this telling us anything more than common sense would tell us anyway?
and it's why, and I don't need the court to refer to it, but it was said that the analysis in Harvey is agreed with. I mean, essentially what the analysis in Harvey says in my submission completely correctly is this is completely consistent with the approach that's directed by the Equality Act. And in my submission, it doesn't advance things any further than that.
I mean, on the facts of a given case, a tribunal could say, we find as a fact, having considered all the evidence, this is likely to recur.
Of course, and if in this case, for instance, if the tribunal hadn't been able to say this arose in circumstances where there was a specific discussion about pay, that led to the flare-up, that was the claimant's own evidence. If it hadn't been able to say that would have concluded and that's the basis of our conclusion on likelihood, then obviously that would be a completely different case. And I would accept in that case the fact that there's an open-ended prognosis would be a completely different thing. But that was not this case. And that is really the nub of what I can say in relation to ground 2 or ground 2 as I've...
On these matters, you might even be prepared to concede that this tribunal or another tribunal might very well have reached other conclusions based upon the information it had, but it didn't.
Yeah,
my
lord, I would be prepared to accept that. I would be prepared. I don't say that
they could only have come to one conclusion.
No, that's why we had 9 days in the employment tribunal with evidence and argument. It's why I don't say, I certainly don't say, and never have said, that if I'm wrong on any of this as a matter of disposal, it can be answered in my favour anyway. These are all questions of fact and assessment and judgment for the first instance tribunal. And it's precisely the same in relation to the likelihood of recurrence. The central point taken is in relation to a matter of principle, doing best I can stick within my 20 minutes that I said I'd be, was in relation to the repeal provisions in the Disability Discrimination Act.
Yes.
They go only to past disability. And the short answer, therefore, and the one given by Mr. Justice Choudhury in the EAT, is that this case isn't, never has been, but still isn't, put as a case of past disability. It's not said by the claimant that I used to have a disability, but in 2017 I no longer was, but I was discriminated against because of that disability that had ceased. What Mr. Milsom's seeking to do is take a repeal, but a repealed provision dealing with a past disability, and say that that compels the tribunal to the conclusion that the claimant had a present disability. And there's simply no justification that, even if one assumes in his favour that somehow the repeal provision can just be read over to the Equality Act.
This is 34 to 36 of the appeal tribunal.
My lord, yes. At core 91, that is the essence, and it's still put in that way. And of course, I've referred, and I won't ask the court to note, but there is a difference in analysis between a case based on present disability and a case based on past. Self-evidently, if someone is required to make a reasonable adjustment for a disability which used to be there but no longer is, that's very different from someone required to make a reasonable adjustment for a disability which attains.
I'm sorry, I'm not. It's my fault. I'm not following this. If you go to the repealed provision of the DDA,
My lord, yes.
in paragraph 5 of Schedule 2.
Yes, my lord.
We just take this slowly, by reference to the words used by Parliament. Where an impairment ceases to have a substantial adverse effect on a person's ability to carry out normal day-to-day activities. Now, that's the premise, that's the factual premise Parliament is asking us to imagine. That an impairment did have a substantial adverse effect on a person's ability to carry out normal day-to-day activities, but it's now ceased to do so, right? Now, why isn't that factually the premise that the tribunal found to exist in September 2013?
So, factually, that premise, yes, the tribunal found the impairment had ceased to have that effect. I go that far, but one needs to look at what the purposes of that. The court's only been taken at the moment to that provision, and not what that provision is actually seeking to achieve.
Right.
Again, perhaps I've tried to be too brief, but if the court looks at the start of that tab, this is at page 483 of the PDF.
Right.
This is the repeal provision on past disability. And so what's saying here, the provision of this part and these other parts apply in relation to a person who has had a disability, as they apply in relation to a person who has. So in other words, they can apply to a past as well as a present disability. And then it says those provisions are subject to the modification made by Schedule 2. And my lord, the paragraph 5 that you were looking at, that your lordship was looking at on page 516 of the PDF, is from so in effect what this is doing is this is modifying the entire statutory regime for a case in which an employee is relying upon a past rather than a present disability. So it's a different part. It's a modification of the regime.
I see. So you accept that the words read by themselves would apply to a case like the present, but when read in statutory context, it doesn't apply because it's concerned with a different thing.
My lord, I'd put it this way. What they certainly can't do is be read over from that context to this context in which it's said they can be used to create a finding that the claimant was presently disabled as at.
Well, I don't understand that. It may be a bad point on its substance, but on the face of it, that seems to be a deeming provision, which says that if it has ceased to have effect, but the effect recurs, it is to be treated as continuing.
But it's a deeming provision that only applies if you're in the realm of making a claim based on your past disability rather than a claim based on your current.
Yeah, that's why I put it to you.
Sorry.
The words on their face could apply, but you say that it's talking about something completely different.
In which case, my lord, that's my apology for misunderstanding your question. If the claim had been framed as one of past disability under the Disability Discrimination Act 1995, then that might have been a way that it could be put.
Yes, I see.
But it wasn't, and it still isn't framed in that way. And that's, of course, before one gets to whether it's possible to just read those provisions over in the way that's said by my learned friend that the court can. In my submission, that can't be done. One of the reasons being, and perhaps if it assists, I could show the court very briefly what is said in relation to the Equality Act in relation to past disability. It's dealt with in a rather different way. This is at tab 25, and it's section 6.4, which is at page 460 of the PDF.
So section 6.
6, subsection 4, my lord.
Yeah. Yes.
Which says this act applies in relation to a person who has had a disability as it applies in relation to a person who has the disability. But what is not replicated in that act is any form of deeming provision or precisely when someone has or not had a past disability. And just for completeness on this point, if it's said it doesn't make a difference whether the case is framed as one of past or present disability, again, I won't ask the court to turn to it, but Swift and the Chief Constable of Wiltshire at tab 5, or page 43 of the PDF, paragraphs 9 and 30 at pages 45 and 47 of the PDF respectively, explain that distinction. Otherwise, this
Gibby, what do you say about the fundamental point that's made based on Blackwood and what Justice Underhill said, that the purpose of the 2010 Act was not really to enact any lessening of discrimination protections? It was a bit of tidying up, basically.
My lord, I'd say 2 points. The first is that that is what his lordship says in that judgment. That can only be taken so far. And to take that as reading over a suite of provisions dealing with past disability which are not replicated in my submission would go beyond that. The second point, my lord, is when it's said that it's somehow this would lessen the protection. One of the difficulties is actually making the provision to which Mr. Milsom referred work in the context of a past disability. And sometimes one person's tidying up can be another making the new provisions work. Beyond that, it's said against me that in respect of the reasoning that the tribunal fell into error despite having directed itself correctly. I made just one additional point to those in my skeleton argument in light of what's been said about the use of the word likely, which is at page 131 of the core bundle, paragraph 102 of the judgment, when dealing with the likelihood of recurrence. The tribunal specifically say likely to recur within the meaning of that provision. And so the suggestion that despite having gone to the trouble to include that and having referred to Boyle a few paragraphs earlier, the tribunal nevertheless applied the wrong test is one in my submission is not merited. In terms of highlights, as I suspect the court gathered, there's not a huge amount for me to say in terms of highlights on the issue of knowledge. This is a case in which I accepted in the EAT that paragraph 105 is a relatively brief paragraph, but it refers to the totality of findings made by the tribunal. The only point which I'd make as an additional highlight in respect of this is the point that's made in respect of there being an insufficient consideration in the judgment of what the employer ought reasonably to have known by making inquiries, in respect of which it's worth noting that one is looking at this as a relevant period. So had the employer made the requisite inquiries at the relevant time, i.e. around September 2017, what reasonably would it have found? And in fact, I raise this because in my submission it's a point that goes in my favour rather than against me. And I don't need to take the court to all the references. They're at paragraph 53 in my skeleton argument, page 66 of the core bundle. But even by November, sometime after the end of the relevant period, the claimant's GP's view was that this wasn't a long-term condition for the purposes of the Equality Act. The claimant's own evidence was that he didn't mention his paranoia or delusions or indeed these security concerns to his GP or until his final CBT session in early 2018. And I raise these points because of the question raised by the Court during Malone and Friends submissions, knowledge of what? Because knowledge is put at a very general level against me in this case. It's said that because there were some emails referring to paranoia and so on, which won't surprise the courts here, were the subject of a great deal of evidence at first instance. This means that therefore there was knowledge of the disability if one was present. What the employer has to know or ought to have known is that each element of the disability test is satisfied, i.e. that there was an impairment which had a substantial adverse effect on the individual's ability to carry out day-to-day activities and which was long-term, i.e. it had lasted 12 months or it was likely to recur. And in circumstances where there was nothing before the respondent to link these events, it's difficult to see what further inquiries revealing the type of information referred to in paragraph 53 would have had.
I don't want to put words in your mouth at all, but I just want to be sure I've understood the submission. If one tests it by reference to my hypothetical example of the person who is deluded that the earth is flat, the employer knows that he has that delusion, continues to have that delusion. But is your point that the employer has no reason to be put on inquiry about its effects, because as far as the employer is concerned, it's not having any material effect on that person's work?
My lord, yes. And in this case, I go one step further, because on that hypothesis, the employer knew of the employee's existing belief that the world was flat. The evidence in this case, as referred to in that paragraph, was that in fact the paranoia, the belief that the claimant was being followed, wasn't something which had been raised by the claimant with either of the managers for several years by the relevant time. So I would go even further. But your point articulates correctly the legal point I'm making about there being a need to be knowledge of each element of the definition. Right. My lord, I was slightly longer than 20 minutes, for which my apologies, but that is a highlight.
Did one of the matters in the paragraph you mentioned is the GP's letter at the supplementary bundle in page 3, setting out what the GP thought about the Equality Act. Was that mentioned by the tribunal, or was that left aside?
It wasn't picked up on by the employment tribunal.
So they neither referred to that opinion, which pointed one way, nor to Miss Watson's opinion, which pointed another way. They looked at the original material.
They focused on Miss Watson's notes as the most contemporaneous thing that was available to them, and then the single joint expert, and then did what the law said they should do and came to their conclusions.
Ms. Lee, we're conscious that we compressed your submissions, but none the worse for that. Thank you very much indeed. Yes, Ms. Wilson.
Yes. On my count, 4 points. Thank you.
There's a persistent belief that lecterns make submissions better.
I'm not sure.
I'm not sure there's any empirical evidence for it.
There are means of hiding things, I'm sure.
Yes.
By the time I set it up, it'll probably be time I finish. But in any event, first point my learner from made is that the failings on ground 1 said that if there's failures to address substantial adverse effect, then those failures cover the period April to August and May to 13 and May to September 13, just as much as they cover the period where we're interested. We agree, and that's part of the problem. Unless you identify what it was that the tribunal regarded as substantial, severe, whatever it might be, in the 2 flare-up periods, there is no basis for the parties or for the appellate tribunal to understand whether the trajectory from those 2 flare-ups is one from severe to substantial or one from severe to minor. You've got to identify the impairments and the effects first. You've got to do the comparative, you've got to undertake the comparative analysis urged by Goodwin, Patterson, Adarami, and Dorset County Council. And as I say, it's not just there. In fact, the principal focus of this appeal is not so much what is there at paragraph 98, but what isn't. I don't say that objective assessments of others or the external presentations can never be taken into account. That's part of the reason why there's no perversity appeal. But it's no substitute for the correct legal analysis. Secondly, guidance. My learned friend overstates my case, both in writing and orally, as I hope is made clear. There may well be scenarios where it's reasonable to disregard the effect, but you have to take it into account. You can't just ignore the guidance. There's a statutory requirement to take account of it. And if it is not reasonable to regard delusions as the only effect, then why not? Thirdly,
I could understand that point if they simply hadn't picked up on the fact that your client had been suffering from delusions. That they were very well aware of that. And there's nothing in the guidance that says that having identified that he suffered from delusions, they therefore have to go on and find that it's a substantial adverse effect.
I think it's important to emphasise what the appendix of the guidance is dealing with. Those effects, if they are the only effects that are presented, are generally to be regarded as substantial, i.e. disabling. That's the point of the guidance.
It would be reasonable to regard
it. It would be reasonable to.
Yes. As I say, it is possible that it's reasonable not to regard it.
Yes, one might think that the effect of the guidance was to make sure that matters that deserve consideration, such as delusions, are not brushed aside as being daydreams.
As being
daydreams. I mean, that proper serious consideration is given to them, but I don't see that it's going on to say, and if you find that somebody has delusions, unless there's something very strange, you're going to have to find that they have a serious adverse effect.
Well, there's the rub. Serious as opposed to substantial.
Well, it's that's my my ignorance.
But,
it's not the point I'm making.
But what we know from the appendix is that those effects and those effects alone are sufficient to be more than minor. What we also know is that this tribunal proceeded on the basis that the delusion in and of itself, whilst an effect, according to the guidance, is not enough to be minor. Why remains a mystery, not least because they didn't have regard to the guidance at all.
But Mr. Milsom, the statutory obligation to have regard to the guidance is in paragraph 12,
yes.
1 of schedule. I forget which schedule it is.
Schedule 1.
Determining whether a person is disabled, an adjudicating body must take account of such guidance as it thinks is relevant. Now, if neither side refers the ET to this particular bit of the guidance, how can the tribunal be criticised for not considering it to be relevant?
Well, there's three problems with that, if I may say, my lady. The first is that the tribunal was directed to it, as the diligent word set of my Lord Justice Jackson revealed.
Not the guidance in general, this particular bit of the guidance that you're relying on.
The second, however unfair it may be viewed, is that the obligation rests with all parties to identify, but also the court or tribunal to be aware of the guidance. And thirdly, I don't believe it's being suggested, it certainly hasn't to date in the appeal either here or below by my learned friend, that guidance which cites as if it were the only effect of the impairment, reasonable to regard it as having substantial adverse effect, delusions, is anything other than relevant.
So in other words, the ET, even when both sides are legally represented, has got to spend time in the course of its deliberations reading every page of the guidance just to check whether the parties have missed something. Is that your submission?
Well, in circumstances where many disabled litigants will be self-represented,
no, I'm not dealing with
the obligation. My lady, I didn't act below. It clearly should have been brought to the attention of the tribunal by both parties. And on the face of it, it was not brought to the attention of the tribunal by the claimant's then representatives.
All right.
I can take that point no further, save that given the large number of unrepresented litigants, given that the tenor of my learned friend submissions is that we are to treat this as an experienced tribunal, and indeed it was, the duty also rests on it to have account of relevant guidance, including the whole point which we're here on ground one, whether delusions are substantial, whether the effects endured by the claimant were more than minor or trivial. And this is why we've got the problem with the comparative exercise. That persisted throughout. It does rather look as though the tribunal elevated the flare-up periods to questions of severity rather than beyond the insubstantial.
Can I put a question to you, Mr. Milson?
Certainly can, my lord.
Because I don't want anyone to leave this hearing without this being entirely clear, because I may have misunderstood the submission. Can I put to you that, speaking for myself only, and only on a provisional basis, I think the guidance is just wrong, because it confuses the concept of an underlying condition, namely a delusion, with the concept of what its effects may be.
Well, the guidance was laid before Parliament. The schedule of the Equality Act itself requires regard to be had to the guidance. And there are different medical opinions as to whether delusions should be regarded as impairments or as effects. What we know here is that there was a persistent persecutory delusion, which on the face of the guidance, one would reasonably regard, even if that were the only effect, as having a more than minor or trivial effect. Now, the guidance may be wrong, but Parliament's approved it. And if one compares the list of that which is substantial to that which is minor, inability to converse orally in a language which is not the speaker's native spoken language, that's an example of minor. The purpose of the Act and the purpose of the guidance is to ensure that there is no focus on the peripheral matters, but where it transcends the peripheral, you get to the main event of a disability discrimination claim, which is causation, justification, and reasonableness. The Diode briefly.
This is your third point.
Yeah. We say Diode is relevant not just to the question of likely to last, but likelihood of recurrence. And I don't say that it imposes a bolt-on to the ordinary understanding of the Equality Act. What it does illustrate is that having regard to the directive, the UN Convention, and the purposive role of disability protection, where something is open-ended, where the prognosis is uncertain, a tribunal should proceed carefully in concluding that there is no real possibility of a likelihood either of recurrence or a duration beyond the 12 months. What material did the tribunal have to rule out categorically no real possibility of recurrence or likely duration? The only way to understand its analysis is to say that it was solely focused upon the trigger, pay discussions, rather than the possibility of another trigger, whether at work or beyond, in the future. And one must ask, if somebody deteriorates to such a great scale on a pay dispute, and if there is medical evidence saying that there could be no definitive prognosis, what did the tribunal know that nobody else did? Certainly not spelt out in the judgment. Past disability. Finally, I think you have my points on knowledge, and I don't propose to say any more about them. Past disability. It's important to look at what Para 5 does. Para 5, Schedule 2 of the DDA. It introduces Para 5.2 into Schedule 1 of the DDA, which does not deal with past disability, but the correct approach to definition of disability. And if one looks at the words used at Para 5.2, it's quite clear that it is dealing with something conceptually different to a historic disability. There is a clear conceptual difference. One example being, it would be odd if there was a duty to make adjustments for somebody who was no longer disabled. And on that point, I'm all fours with Mr. Lee. But if one looks at the wording that is in fact used at para 5.2, where an impairment ceases to have a substantial adverse effect on a person's ability to carry out normal day-to-day activities, it is to be treated as continuing. The very opposite of past disability. It's ongoing to have effect if that effect recurs.
But one's looking at it from that end of the telescope, the case where the claim is based upon the first event.
Well, that's not the effect of para 5.2. It's in the past disability schedule, but it introduces words into the definition of disability more widely. That's the effect of para 5.2. It's an odd journey to get there. One might think that an easier way would simply be putting it into Schedule 1, but if one looks at the effect of the deeming provision, a para 5, albeit in an unusual schedule, it's not really dealing with historic disabilities, it's dealing with those where the effect is ongoing. And it doesn't seek to introduce that wording into Schedule 2, it transposes it into Schedule 1.
Yes, but only in the circumstances described in Section 2.
No. This is para 5 of Schedule 2. What you have at the beginning is Section 2.
Right.
So Section 2 of the Act is that which deals with past disabilities.
Yes.
There's then a schedule which deals with past disabilities, or was a schedule that deals with past disabilities.
Yeah.
Schedule 2.
Yeah.
But what para 5 of Schedule 2 does, somewhat bizarrely one might think, is introduce words which are clearly dealing with continuing and ongoing effects back into Schedule 1.
Yeah, but the words of Schedule 1 are only modified by the effect of Section 2, subsection 2, Section 2, subsection 2, and that only comes into play where a person is a person who had a disability and no longer has it.
Well,
So it's not a general modification of the provisions of Schedule 1, it's a modification of the provisions of Schedule 1 in limited circumstances.
well, Schedule 2 contains more. I mean, it does occur to me that my lady and my lordships may benefit from seeing the Act in a kind of broader structure than the citations you have, because it's labyrinthine in its effects.
Which Act?
The DDA.
Yes, I know we're spending a considerable amount of time trying to work out what a repealed statute.
Well, you have my point on.
Yes,
it would be very bizarre indeed.
Yes, you say it wasn't a regressive piece of legislation.
It was not a regressive piece of legislation, even with rather more express wording than this, such as it is not a contravention of this section to undergo post-employment victimisation, as in Jessamy, even on express statutory wording, that this court has never concluded.
So we'll have to do our best to work out what those schedule provisions of the repealed legislation actually did,
yes,
and then to see what, if any, light they shine on the current legislation.
Yes, but in short, Section 2.2 refers to Schedule 2. That much we can agree on, my lady.
Yeah.
Schedule 2 contains an awful lot more than Para 5.
Yes.
For one, Paras 1 to 4.
Yes.
What Para 5 does is seek to introduce wording into Schedule 1,
Yes.
definition of disability, which is much wider than disabilities which are merely historic. And there's no way of reading Para 5.2 as being confined to historic disabilities. It's dealing with continuing effects.
If you take the language on its own, but it
Yes.
only applies as enacted in Section 2, subsection 2, in a case where someone who has had a disability. Anyway, all right. Well, I think I've got your point.
So be it. And I think you have my broader point on why on earth should the claimant go back to 0 in 2017 in circumstances where this is another flare-up of an underlying condition the employer has known about for 4 years. My Lady, my Lords, if, to the best certainly of my knowledge, and as I understand Mr. Lee's as well, this is the first occasion on which this court has grappled with the questions of likelihood and substantiality. You have a lot of decisions from the EAT, little indeed, to our knowledge, there's nothing at all on substantiality from this court, which is why we've spent so much time on guidance from precedents on other occasions. As I say, my Lord Justice Jackson may have some questions as to whether I can multi-hat with both the Commission and the appellant, but if there is anything on which I can assist on the correct approach to guidance, on anything that I've addressed, of course, I'm happy to.
No, unless my Lord or my Lady has anything further to ask you. Mr. Wilson, thank you very much for your help with this.
Thank you, Mel.
Now, inevitably, we will take time to consider the matter, and we will let you have our judgments in due course in draft for the usual editorial process. Please, and the agreement of a draft order, the indication of any points of disagreement with some short arguments one way or the other on them. We hope there won't need to be any. We'll then hand down the judgments, in all likelihood electronically, in due course in the normal way, following which they'll be published. Unless there are any other matters that either of you would wish to raise, that would conclude the hearing.
Thank you, Mel.
Thank you very much indeed.
Full class?